See, yeah. Okay. So first case I wanted to talk about then in the context of the family, just for you to reflect on and ponder what might have been the judgment, the decision by the Supreme Court in this case, before going on to look at the text. Okay, so it's the Murphy case, Murphy and the Attorney General from 1982. And it concerns a married couple, Francis and Mary Murphy, Frank and Mary Murphy, who I think were public servants, may have been teachers. I suppose it doesn't really matter, but in any case, they were both paying tax. Okay, they had salaries and were paying tax on the salaries. Now, I don't want to overcomplicate things, so hopefully this doesn't confuse you, because in many ways, for our purposes, the case is pretty simple. In simple summary terms, Frank and Mary Murphy were paying more tax than they would have been paying if they were not married. And they challenged the constitutionality of the provisions of the Finance Acts that brought about that result. Okay, and the question is, did they win or didn't they win? But just so you have so that's the simple summary. I mean, it's no more complicated than that. Right, but so just you have a picture, or a better picture maybe, of the case, and you'll be able to recall it a little more clearly. Let me just kind of give you a little more detail on it. And of course, this is rough now, summary, and I'm using exaggerated figures here just to make the point as easy as possible. But let's suppose they're both earning 50,000, at the time it would have been pounds, of course, each. That's their salary. And suppose that the upper rate of tax is 50%, the higher rate of tax on, is 50%, and the lower rate of tax is 10%. And let's suppose that the higher rate of tax kicks in at 50,000 euros. Once you earn anything above that, then you're paying 50%. Anything you earn below that, you're paying 10%. Right, well, if you think about it, the provisions that Frank and Mary Murphy challenged in the Finance Acts effectively meant that they, Frank and Mary Murphy, would be assessed for their income tax as if they were one individual. In other words, there was one individual earning £100,000. If they were not married, they'd have been assessed separately as two people, each of them earning 50,000. So if you do the maths, I'll try and do them quickly. If you do the maths, they on the 50,000, on the first 50,000, they're being charged isn't it 10%? So that's 5,000 euros in tax. On the next 50,000, they're being charged 50%, which is 25,000. So they've got a total tax bill of 35,000. Now, if they weren't married, Frank Murphy would be paying 5%. He'd be paying, 5,000, 10% of 50, 5,000. And Mary Murphy would be paying the same on her 50,000. So that's only 10,000 euros versus 35. Now, of course, they're exaggerated figures, but you get the point. So they challenged the constitutionality. Now, remember, they got married in 1975. They initiated their action in the High Court in 1978. And the decision wasn't actually handed down by this, well, it was the High Court ruled first, of course, but then appealed to the Supreme Court. The final decision of the Supreme Court didn't come until 1982. Right, so did they win? Do you think that they won the case? Now, think about it now, but I suppose when we look at the text of the Constitution in a minute, think about whether you feel that they likely did or didn't win. Or put the question another way, actually, in a more interesting way, actually, might be, do you think they ought to win? Maybe as a question of just political morality, for want of a better phrase, or as a question of constitutional law. Do you think they should win their case? And as always, guys, I'd be very, very happy, and thanks now, there's more people with screens on, that's fantastic. I'd be very happy for you to interrupt me at any time and discuss this, or offer your view or your sense of things. So that's Murphy. We'll come back to it. And then there's another case I wanted to introduce to you at the start called Mhic Mhathuna and Ireland from 1989, spelt I'll spell it on the chat. Well, let me just record that one, pause that as the Murphy and Attorney General case. No, sorry, I'll continue. Sorry, because we didn't really get to the end of that. So Mhic Mhathúna is spelt as follows. Vic. I can't do a Vahuna. Now that should be a father on the U. Oh, sorry. Okay, Mhic Mhathúna. There should be a father on that U, of course, but Mhic Mhathúna against Ireland from 1989. Now this is a kind of an interesting one, because you guys probably have never heard of Una Mhic Mhathúna. She was before my time as well, now I have to say, but or at least I wasn't. I was alive in the 1990s, but I wasn't aware of Una Mhic Mhathúna. But she famously, on RTE TV on the night of the election count for the referendum on divorce in 1995, when it emerged that yes had won by a fraction, by 10,000 votes, 50.5% to 49.5, or even tighter than that. But when it emerged that they had won and they were being interviewed on RTE, she was standing nearby and famously shouted, "Go away, ye wife-swapping sodomites," to the yes campaigners, right? So she was a prominent conservative campaigner in those referendums on abortion and divorce in the 80s and 90s. And she was married to a man, they had 9 kids, and they took a case challenging the constitutionality of a few pieces of legislation that basically gave support, financial supports, to single mothers at the time. So there was, for instance, a provision that gave the single mother's allowance, okay, whatever it was, a week or a month, and also a tax credit, a tax-free allowance for single, I guess it would be single parents if it was today. I think as it was phrased at the time, it was single mothers. Now, their argument was that these were supports that were available to unmarried mothers that were not available to married mothers, so that there was a discrimination in favor of unmarried people, thereby, as the Mhic Mhathúna saw it, incentivizing not getting married. And so they challenged the constitutionality, again, on the basis of Article 41. So again, the question is, well, one question is, should they, as a matter of political morality, win their case? I'm guessing very much that most of you, if not perhaps all of you, think, no, they should not win as a matter of political morality. As a matter of constitutional law, should they win, is the more interesting question. As a matter of constitutional law, should they win? And why? So with that, let's take a look at the text of the Constitution. Now I'm going to stop that recording because I don't like them going too long and they take too long to load. And then I'll start again. So